Hello and welcome to the Kevin Mannix Report. I'm Kevin Mannix, your host for this program. This is designed to give us all a little more insight into officials who are involved in government and politics in our community. And our guest today is someone who is not so much involved in politics as in government on the judicial side of things, the Honorable Paul Lipscomb, who is the presiding judge of the Marion County Circuit Court. Welcome to the show.
Thank you, Kevin. It's nice to be here to chat with you today.
One of the things we like to do on this program is give folks a little more insight into the personalities and background of people in government, because when you read about things in the papers or you hear about them on TV or whatever, you often don't have any idea about the personality of the individual behind the scenes or behind the news. So we always like to get a little bit of background information. Can you tell us a little about where you're from and where you went to school?
Sure. I grew up in the Midwest, in Milwaukee, Wisconsin. I was from a large family. I was one of 12 kids. I went to the East Coast to school. I went to Dartmouth College in New Hampshire. And then I lived for 2 years got married and lived and went to work on the Navajo Reservation for 2 years down in Arizona. And then following that, went back to the East Coast to law school at Boston University.
Can I interrupt and ask, what kind of work did you do on the Navajo Reservation?
Well, it was 1970 to 1972, so it was a time when there was a fair amount of social turmoil here in the United States. And I was looking for an alternative. My wife and I were both looking for something of somewhat alternative nature that we could do. I had acquired a significant loan burden while I was as an undergraduate in college, and I needed to earn some money to pay that off, but I didn't want to go into a standard job. I wanted to do something meaningful, something that would be both personally rewarding and would help others. And we came upon an opportunity to work for the Bureau of Indian Affairs on an Indian reservation, and we were selected to go to the Navajo Reservation in Arizona. The Navajo Reservation is a very large geographical area. It's the size of the state of West Virginia, and a lot of people don't realize that it actually comprises parts of 4 different states. And the Navajos, particularly then, but I think still now, were originally a fairly nomadic people, and they tend still not to settle in villages. There's isolated little communities spread out across a high altitude desert, much like far eastern, southeastern Oregon.
So were you assigned to work with those various communities?
We were actually assigned to work with a school that was a boarding school, sort of a magnet community. About 50 miles into the reservation, about 50 miles north of Winslow, Arizona, right on the border with the Hopi Reservation. And the Navajo children would come in by pickup truck, by horse and wagon, literally, and be dropped off at the school, usually Sunday evening, sometimes Monday morning. And they'd stay for the week, and then about 70% of them would return home for the weekend, usually in the same fashion. Some of the kids didn't get to go home quite that often, every 2 or 3 weeks.
So basically it was a boarding school.
It was a boarding school. We didn't have any day students at all. It was a boarding school, and I ran the dormitory program. And these were from kids kindergarten age through 4th grade at our school. We had a fairly small school. And then they would transfer to one of the larger schools thereafter.
Well, in that kind of environment, were you thinking ahead, thinking that you'd like to go to law school and become a lawyer, or was that something you just hadn't thought about at the time?
No, when I was in college, again, that was the late 60s, and I pretty much determined that I wanted to go into law at that point. My original idea when I started college was to be an English professor, but I changed my mind during the course of my studies, my course of my undergraduate education, decided I wanted to go into law, basically because I wanted something that would both empower me as an individual, and that wasn't a word we used back then, but I think that's an apt description, and also one that would give me the tools to make a difference, not only in my community, but really in the world. as Kevin, I'm sure you remember, the late 60s, early 70s were a time when many people in our generation really sort of took on a cloak or a mantle of the challenge of really doing something different and making a change, making a difference in our world.
Well, then you went on to law school to get that education to help, that further education to help you make a difference. Can you tell us a little about your law school experience?
I'm one of those crazy people that actually loved law school. I really enjoyed the intellectual challenge. I liked the camaraderie of working on common problems with other students, the intellectual discussions that went along with that. And while I was in law school, I decided I would someday want to become a judge. I liked what it seemed to be the process of judicial decision-making that we studied in law school, as you did. Excuse me. And so when we got, when I was married at the time, but when I got to the end of second year, I sat down and discussed with my wife what we were going to do as a young family. We didn't have kids yet, but we were planning to have children soon. Where we would settle down and live, what I should be looking for in terms of job opportunities, etc.
As of that time, did you have any Oregon connection, or is this something that I'm just curious about this discussion at that point?
Well, I was about to get to that, and we talked about where we wanted to live. And we decided that we really liked New England, and particularly the Maine coast, and had thought since we were in college that we'd like to live on the Maine coast. We learned while we were in Boston that the Maine coast, although it's beautiful, tends to be very snowy and cold in the winter, and very warm and full of tourists in the summer. People come up from New York and Boston, they come down from Montreal, and it's really quite crowded, and it loses a lot of its pristine beauty. So we were talking about it, and I told Donna that I had been to Oregon when I was in high school, and I came out on a National Science Foundation summer program for science students between my junior and senior year in high school. And I spent 6 weeks down at Oregon State University at the campus there, and we took field trips and studied oceanography and meteorology and geology.
So you had quite an introduction to Oregon.
And I just loved it. I was a kid from the Midwest. I'd never seen a mountain before. I'd never seen the ocean before. It was the summertime. The weather was beautiful.
So we fooled you that way.
Yeah, it really was a wonderful experience. So I was explaining all this to Donna and my wife, and well, we decided to give it a try. So she came out with me on an interview trip, and I interviewed with Judge Howell on the Oregon Supreme Court, and he offered me a job right off the bat, and I accepted it.
So now you took your degree in '75, am I guessing right?
Right. I graduated from law school in 1975.
And you came out here and you clerked for Judge Howell or Justice Howell on the Oregon Supreme Court. Did you do that for a year or 2 years? Some clerks did it for 2 years.
I signed up for a year, but about a month into the experience, I went to Judge Howell and asked him if I could stay another year because I really was enjoying it, and we were getting along really well. And he was grateful for the opportunity to keep me around. He meant he wouldn't have to interview, someone else. And it was really a wonderful experience for me, and a very formative experience as well.
Now, a lot of folks may not understand what a law clerk to a judge is, and particularly back then, well, and probably still so today in the Oregon Supreme Court, which has a much lower volume of cases than the Court of Appeals. The law clerk is there as, I'll almost say, the assistant to the judge doing research and drafting memoranda about cases. But I should probably ask you from your perspective what the job was all about.
I think that's a very good generic description of what a law clerk does. But each justice tends to use his or her clerk a little differently. And Judge Howell was an individual who, as he became more comfortable with you and gained more trust in your work, was willing to give me first draft opinions to work on, and then eventually was letting me draft proposed opinions for his signature to be promulgated amongst the other judges on the bench, and eventually some of them actually became Supreme Court decisions.
Did that develop, and I know you there's always confidentiality in these relationships, so I don't want to push too hard, but when I clerked for Judge Foley, as he became more comfortable with me, he would sit down and say, well, we judges have met, it was a 3-judge panel usually with the Court of Appeals, and we think this case should be moving in this direction. We'd like you to write a draft moving in that direction, but if you see any obstacles to that, let us know. So he would give you more, he gave me more and more opportunities to really be drafting these rough drafts of opinions, and over time, of course, they became more polished. Is that the kind of routine that you were able to establish with Judge Howell?
Yes, and that's how it was early on. Actually, once or twice towards the end, he gave me decisions where the court was divided and there really was no clear direction. And basically the charge was, look into this, give us a draft of the way you think it should be. Most often that's the way it worked out. I remember very clearly I was firmly convinced that it ought to be one particular way, and I wrote a proposed decision. It went into conference with the other justices, and the clerks, of course, are nobody's in conference other than the judges. And it came out, and Judge Howell called me up to his office, and he said, well, Paul, they really loved the opinion, they liked the research, they don't want to change anything except the result. So he asked me to redraft the last paragraph, and that was an interesting experience.
Well, it's sort of like you were going down a trail, and the analysis would lead you in a certain direction, and finally there may have been a fork in the trail, and you could choose one course or the other, and they said, from their perspective, choose the other fork.
That's exactly right, and as in many areas of appellate law, this one was a criminal decision, but in many areas of appellate law, there are 2 roads that you can take. There's support on each side of a difficult question, and it really does oftentimes become a policy choice for the court to make as to when you are on the cusp, which direction you head in any particular individual case.
So after these 2 years of this academically stimulating, I would think, experience.
It was wonderful, really was wonderful.
Did you move into private practice or government service or what?
Yes, and Justice Howell, as well as my first legal employer, was my mentor, and really was my mentor throughout my professional life until his death a couple of years back. He and I sat down and talked about my career goals. He knew that I wanted to become a judge very much. And my initial inclination was to apply for a job in the appellate division of the Department of Justice and to go into appellate law, because I thought that's what I wanted to do, is become a Supreme Court justice just like Judge Howell someday. And he urged me not to do that. He felt it was really important that I go into private practice, learn what it would be like to be a lawyer earning a living as a small businessman, and develop some trust with the lawyers in the local legal community, get to know what the problems of being a trial lawyer were, and then become a trial judge before I sought higher office.
Sounds like there was excellent advice for you.
It was terrific, because what I found, I enjoyed private practice, and I did that for about 10 years, and then I ran for election to what was then the Marion County District Court. What I found when I was on the District Court is I really enjoyed it. I enjoyed the process, I enjoyed the people, I liked the litigants, and I learned a tremendous amount about my community, about human nature, and about myself. So it was really, it's been an excellent experience for me and a wonderful career.
I would think that, too, the actual trial practice and then being on the trial bench would help anyone who would aspire to an appellate court position because of the nature of the background that you develop. I still remember once when Judge Foley, and I can't mention the case, of course, but Judge Foley advised me that the court wanted to move a particular way as to a ruling made by a trial judge. And from the record, I really, as a neophyte lawyer, couldn't quite understand why they were moving that way. And he sat me down and he explained, let me tell you, Kevin, what was really going on in the courtroom that day, and even though the cold hard record shows this, I know what this judge, the predicament he was facing and what was likely going on, and this is why we think it's best to have moved in this direction and uphold the judge. And he had tremendous insight, because he had been a circuit court judge, as to what I'll call the real world, and not everything that is said can give you the flavor. And sometimes, and that's not something you put into an opinion, but it helps them understand what's going on. Is that part of the world experience you think that's important to carry on?
I think it's really important, and I think it's of critical importance today. I've told this to several other people before, but when we were clerks, when you were working in the Court of Appeals, and when I was clerking as well, about 80% of the appellate judges were former trial judges. And about 20% were a smattering of folks from academic pursuits or from district attorney from Portland, for example, that sort of thing. So that there was a good mix of individuals' backgrounds and experiences. But the nucleus of the appellate judges was always former trial judges. And that makes sense because the bulk of the work that's done by the appellate courts is reviewing trial court decisions. Yeah, there's been a real push to increase the diversity of backgrounds coming to the appellate courts. And we're now to the point where about 20% of the court is made up of former trial court judges and about 80% from other walks of legal life. And that's been good in some respects, and it's been healthy in some respects, but I think it's time for the pendulum to shift back. I'm with you. I really think it makes a real difference on the appellate court. It's hard to point to in any particular case where it makes a difference, but I'm convinced that overall it makes a tremendous difference if the bulk of the makeup of the court is made up with former trial court judges. Certainly a strong percentage.
We're going to pause for a moment so that I can mention to our audience that you're with us on the Kevin Mannix Report. I'm Kevin Mannix, I guess that's pretty obvious, the host of this program. Our guest today is Judge Paul Lipscomb, who is the presiding judge of the Marion County Circuit Court. And in fact, in a couple of minutes, we'll get into what that job is all about. If you ever have any questions or concerns, I hope you'll feel free to contact us. You can write to us at 2003 State Street, Salem, Oregon, 97301, or you can phone. Normally we have a recorded voicemail system because that phone is intended all the time, but please do leave a message and we will get back to you promptly. We're always happy to hear from folks. Well, Judge, we're back to you, and it was a good point to segue and just let folks know about the program, but this is an interesting conversation piece because the public elects judges, but also the governor plays a very important role in this process because often there's a vacancy in the trial courts or in the appellate courts, and the governor will then appoint someone who will serve out the remainder of a term or until the next election when that person has to be running for election. Do you have any tips that you could pass on to people as to what they ought to look at in trying to evaluate judicial candidates? Because it's a real mystery to people.
I think the public should be principally interested in experience. I think particularly at the appellate court level, experience is what counts. You need obviously a strong moral fiber, a strong value system that's well grounded. But beyond that, I think it's the experience base that each judge brings to the job that makes the difference at the appellate level. You have to be able to put things in context, keep them in context. It's important to have a good, really scholarly ability to deal with the law and sometimes the intricacies of the law. But it's important to remain practical as well. And I think it's the experience that a judge has on a daily basis dealing with real people and real problems that allows the judge to stay practical when you move beyond dealing with individual folks and individual cases and enter the semi-ethereal realm, if you will, of the appellate courts, where you are setting precedents not only for the particular case that's before you, but really charting a course for the future as well.
Well, with that in mind, when you got on the district court bench in Marion County, What was the experience like? I guess I should pause for a moment and point out that the district court has now been merged with the circuit court, so we have one trial level court in every county or circuit, so that what was a higher level trial court, the circuit court, and a supposedly lower level trial court, the district court, are now one. And you've transitioned through that, and of course you joined the circuit court before the merger occurred, and now you've been on circuit court for, what, 6 years?
5.
5 years. But what was it like when you first got on the bench?
It was really interesting because district court is, well, then the jurisdiction was civil cases up to $2,500. It was shortly thereafter boosted to $10,000, but it was still fairly minor civil litigation. And the bulk of the business of the court was made up with misdemeanor criminal cases. And so one way or another, we were dealing with low-level criminal cases and the other foibles of human life. We didn't see a lot of bad people. We saw a lot of people who had made mistakes, and a lot of people. It's a real volume court. Everything from reckless driving and drunk driving through domestic violence cases on the criminal side, and small claims cases, landlord-tenant cases, what we called FEDs, forcible entry and detainer, and beefs between neighbors, and just the everyday human kinds of problems that the people in our local neighborhoods experience on a daily basis and need some assistance in sorting out.
And did you enjoy helping sort those things out?
I did. I became to realize that I was more of a people person than I had really taken stock before and given myself credit for. I enjoy the people contact. It's really personally rewarding for me to be able to help other people, to assist them in improving their lives, and this has been a good avenue for me to do that.
Well, now you're the presiding judge of the circuit court. Can you explain how that role differs a little, or how it's a supplemental aspect of the job?
Well, I was going to say I was a district court judge for 7 years, and then there was an opening on the circuit court when Val Sloper stepped down. Val was just a tremendous jurist and had been, I think, for 35 years, really an icon in the Marion County court system. And I was fortunate enough to be selected by the governor to fill his position when he stepped down. And that was back in 1993, late 1993, and then in 1994 I was selected by my peers and then chosen by Chief Justice Wally Carson to be the presiding judge for Marion County. And the role of the presiding judge is sort of, as some people say, first among equals, but it's really, that's not it. The role of the presiding judge is sort of chairman of the board. That's the way I've approached the job, where the judges on the court are the board of directors for the court, the policy setting group, and the presiding judge is simply the chairman of the board, the one that helps keep things on track and move them from one direction to another.
Well, from that perspective, we've got about 6 minutes left in the show, and I'd like to see us move a little bit then into some of the issues that you see confronting the trial level courts in the state, whether it be caseload, the dynamics of the judicial process. What are some of the hot spots and actually some of the success stories that we've seen in circuit courts in the state?
Well, the role of courts has changed a lot in this community throughout the state, really, in the last 10 to 15 years. We're less focused on jury trials than we were when you and I first became lawyers, Kevin. We do more alternative dispute resolution. We do more mediation, arbitration, settlement conferences, other ways of getting cases to a final disposition.
I should get us to pause and explain, too, then, what these mean as alternative methods of dispute resolution. Mediation is, in effect, working with the parties to get them to resolve their differences. Arbitration is a system where they choose somebody to decide the issues for them. Can you explain a little more about this process?
Yes, and arbitration is much like a judicial proceeding, except it takes place in a much less formal, more comfortable atmosphere for many folks, and it's cheaper because it's not subject to the same hard and fast rules of evidence. It's a little looser, more relaxed process. but often comes up with an equally gratifying result for the participants. Mediation really is probably the best way of resolving a dispute or a difficulty if it works in a particular case, because the litigants never give up their case. They control their case until they say yes. So they maintain the control over their dispute, and they're not forced to do anything that they don't want to. As a result, what we've found is that people are more satisfied with the results that are obtained and honor their commitments far better than they do if they're ordered into a particular course of conduct. So that's been a real successful change. It's also cheaper for folks. I think that's really probably been the most beneficial change in the court system within the last 10 years or so.
Now, when we end up with the formalistic jury trial, Marion County has had a pilot program to make jury service and leisure. Can you outline that? Yeah,
and it really goes with our theme of trying to improve service to the citizens in every way. We've adopted really a service-oriented approach over the last 6 years or so, and more so, I think, every year. We went to a one-day, one-trial system for jurors so that instead of being stuck on jury duty for a month or 2 weeks or sometimes longer, an individual is able to complete their jury service simply by showing up and being available at least for a day and for no longer than one trial. We've done studies that indicate that the average, about 80% of the jurors actually get their jury service over with a single day of service, and for the great majority, far exceeding 90%, folks are done in 2 days.
Now, with that more positive and service-oriented dynamic, I would assume that you're more comfortable too in demanding that people actually serve on juries or carry out their service, since it's not going to blow away someone's pay for 30 days or whatever.
Right, and that's been a real significant change, and it's been something of an adjustment for our citizenry, truthfully. Jury service, because it was so onerous, was something that was easy to avoid. In Marion County, anyway, it's no longer easy to avoid because it's really something that anyone or nearly anyone can do. It's very difficult to get excused from jury service. Doesn't matter if you're a heart surgeon. Doesn't matter if you're the governor of the state of Oregon. You're going to come serve. And actually, we've had one governor actually serve on jury duty, and our current governor is scheduled later this summer.
Well, that could be a very interesting case.
Yeah.
We've got about 2 minutes left, and perhaps you could give us some indication of some trends that you would like to see accentuated, some things that we could build on for the courts.
I think the shift in gears to become more service-oriented is really important. We have recently begun and become somewhat of a leader in the area of dealing with litigants without lawyers, particularly in the divorce arena, in the child custody area, but also in probate. And what we've done is
and that's when someone's died and you have to process the estate.
Right. What we've done is tried to make the court system more accessible and user-friendly, if I can borrow a term from the computer age, so that people aren't so intimidated. That if it's a relatively minor matter, if it doesn't involve a lot of money or a risk to someone's liberty, that people can access the courts without lawyers and get their dispute resolved or get some assistance in resolving their dispute themselves. And that's an area that we're shifting really towards, rather than resolving all the disputes ourselves, really to reach out to the community and give people additional tools to assist them in resolving their own disputes.
On that positive note, we're going to have to close the program. Thank you very much for joining us, Judge. And I'll say to our audience, thanks for joining us on the Kevin Mannix Report. Take care.
Thank you, Kevin.